landlords in the state of New York. We recently produced a video showing you how you can challenge the tenant's certification of the Declaration of Hardship. It was a very good video that would more than likely show that you would win your case. But now, roadblocks have been put up against landlords to challenge this declaration. And those roadblocks are: this is the Landlord Advocates, where we help landlords become better landlords. I'm your host, Matthew Lyman. Welcome. Landlords, within the span of 2 weeks, 2 different courts in 2 different judicial districts of the state of New York issued polar opposite decisions in reference to landlords, petitioner landlords, challenging the Declaration of Hardship. We're going to go over the one that made it feasible for landlords to challenge it. We're going to look over that decision and share that with you. Then we're going to look at the court that makes it virtually impossible to challenge this declaration. The first comes from the 3rd Judicial District of the state of New York. That's upstate New York. This particular judge, we are well aware of. He is very fair. We have spoken to him before. He is fair. Well, his decision looked at the COVID Emergency Eviction and Foreclosure Prevention Act, Section 10. Now, Section 10 references how the landlord can challenge the tenant's self-certification of this Declaration of Hardship. But what he looked at was it did not clearly state, the legislature did not clearly state where the burden of persuasion or the burden of production lies. His first ruling regarding that was the burden of production. And what he stated was that the burden of production was on the tenant, as the tenant possesses all the evidence of hardship. Now, in a normal civil litigation case, there are methods deployed to gather evidence against one party and the other. That normally is called a subpoena or a subpoena ducis tecum. A subpoena ducis tecum is to produce records to help the parties seeking those records to win their case. In a summary proceeding, though, they are frowned upon, they're discouraged, because it removes the spirit of summary proceeding. A quick case. Get it done, get it over with within 2 or 3 weeks. But on behalf of landlords, if that is a tool that can be necessary to gather the evidence to help win the eviction that we are seeking, we're okay with that. But the judge goes one step further. He said that to bridge the evidentiary gap, the court imposes upon the tenants the burden of production and evidence of the hardship. That means the tenant must come to court, must come forward and produce the evidence to support their claim of hardship. The lack of evidence to support a claim should be and will be construed against the tenant. That means the tenant has to produce all of the information, all of the documentation, in order to substantiate their claim that they are suffering a hardship, which most of us know they're not. He goes on to say that the burden of persuasion is that of the petitioner landlord. That it is up to you to persuade the court that the tenant is in fact not suffering and that their claim of declaration of hardship is invalid. We landlords are okay with that, but we need the documentation in order to prove that. And the court has imposed upon the tenants to bring forth those documents speedily in order to resolve this case. Not months out, but this case is being heard within 3 weeks of its first appearance. He goes on to state, order that the tenant present evidence and proof regarding hardship at the time and date of the hearing. It is further ordered that if evidence that would support a hardship is not produced the court shall draw an inference against the tenant, meaning that if the tenant does not produce this evidence, the landlord will win their case of proving that the tenant's declaration of hardship is invalid, and they will acquire, at the very least, the warrant of eviction to remove those tenants from the dwelling. He goes on to state that it is up to the landlord to bear the burden of proof that the tenant is not suffering. Again, we're okay with that. He ordered that there will be no adjournment will be granted to gather or produce evidence on the hearing date absent an extraordinary circumstance, like a death of the family or something to that effect. We support that. We're okay with that. You are opening up the door, Judge, to the evidence being provided in court for us to take that evidence and invalidate it. We support that. But now, let's go on to the decision of the other court. This other court is located in the 4th Judicial District, again, upstate New York. Now, we've had many dealings with this judge, and I would personally tell you that I like him. He's a nice person. But that being said, our team and the landlord advocates clearly and definitively disagree with his decision on the challenging of the hardship declaration. The court had the hearing and was having a hearing on the eviction on a nuisance. That was decided on, and that will be for a future video. But it went on that the petitioner sought to challenge the declaration and served the respondent with a subpoena ducis tecum. That was our team. Our team served the subpoena upon a tenant in court to produce the records to claim that they are not suffering this hardship that they claim that they are. The court inquired as to petitioner's good faith basis for the challenge, that all the evidence to support his challenge was solely in the possession of the respondent. That goes right along with what the judge said in the 3rd Judicial District, that the tenant has all of the evidence and possesses all of the evidence of the hardship. We use that same argument to say that the tenant had the possession. Based upon the same, the court denied the petitioner request for a hearing. He denied the request. He put it therefore out until January 18, 2022. His reasoning for that is such. An attorney of record for a party may issue subpoenas to a non-party requiring the production of documents at a hearing or a trial. And he cites Civil Practice Law and Rules 2301. However, it is well settled that a subpoena ducis tecum may not be used for the purpose of discovery or to ascertain the existence of evidence. He cites Matter of Terry D. in the 2nd Department from 1993. But here is where we vehemently disagree with him and say that he is wrong. And here's why. Civil Practice Law and Rules, Rule 3120, it states that after the commencement of an action, that any party may serve on any other party a notice or any other person is subpoena ducis tecum. And the reason for that being is to produce and permit the party seeking discovery or someone who acted on his or her behalf to inspect, copy, test, or photograph any designated documents or any things which are in the possession, custody, or control of the party or person served. That is what we did. Our team served the subpoena on these tenants to ask for them to produce the evidence by which they are stating that they are suffering the declaration of hardship. In this case, the judge said no, they are not going to enforce it. So because they're not going to enforce it, it makes it very difficult for us to be able to prove our case. He states further that the court finds the petitioner's subpoena unenforceable and defective as respondent is a party to this proceeding. It clearly states that you're able to do that. It clearly states also as well under www.nycourts.gov how to subpoena documents or records. If you require an individual to produce a record or document necessary for your case, you may apply to the clerk of the court for a subpoena ducis tecum. This document, once signed by the court, will direct someone to produce a bill, receipt, or other document in his or her possession or under his or her control. Now, the court can issue a subpoena as well as an attorney is an officer of the court. In this case, our team issued the subpoena as an officer of the court to the respondent tenant. And this court has decided that that's not the case, that they cannot do that, that it's invalid, and therefore the court will not enforce the subpoena and will not hold the tenant in contempt of not answering that subpoena. This judge goes further on to state that the subpoena is overly broad and unduly burdensome. Really, Judge? Really? Unduly broad? Overly broad and unduly burdensome? Okay, it's 5 pages long. We want the tenant to produce everything that they possibly have in order for us to win our case. They made the claim of hardship. Now we want them to be able to prove it. And the judge in the 3rd Judicial District stated that that is exactly what the tenant must do. Produce the information to back up their claim, and the landlord will be able to look at that evidence and refute that claim and prove to the court that the tenant did not have the right to sign this Declaration of Hardship. This judge in the 4th Judicial District said, nope, not going to happen, we're not going to enforce it, does not have to answer the subpoena. He states that it's confidential and or private information, and it is being used for purposes of discovery or to ascertain the existence of evidence. Judge, Civil Practice Law Rule CPLR, Rule number 3120, clearly states to produce and permit the parties seeking discovery. That's what the subpoena is for. We're seeking discovery. It even states at nycourts.gov. It clearly states to produce a record or document necessary for your case. So www.2.nycourts.gov states that we can do this. CPLR Rule number 3120 states that we can do this. But this court states that you can't. Based upon the same, petitioner's subpoena is non-enforceable and cannot be grounds for striking the declaration or holding respondent in contempt of court. So what are landlords supposed to do? The only other possibility that you may have that can cost you hundreds, if not thousands of dollars, is for the landlords to hire a New York State licensed private investigator, of which yours truly was one for a number of years. You would have to hire one of us to do massive research to get enough evidence beyond the preponderance of the evidence to prove that the Declaration of Hardship is invalid, for you to get the warrant of eviction and possibly a judgment for the back rent that the tenant owes you. It is cumbersome, it is obnoxious, it is wrong. We believe that this judge in the 4th Judicial District is very wrong. Our team is looking to appeal this case on behalf of landlords, not only in the 4th Judicial District, but all over the 62 counties of New York State to say this is wrong, the tenant needs to produce the evidence, to say that, yeah, I'm suffering and here's why. To simply sign the declaration and not having to worry about any burden of proof is wrong, it's unfair, and by virtue of the laws here in the state of New York, they are mandated to do so, but this court and other courts in New York State are saying, no, that is not the case. Landlords, we will keep in touch, we will keep you abreast of what's going on with this, we will let you know any new developments. Until then, we ask that you subscribe to our channel, hit the like button, hit the notification bell, leave comments below. As we read them, we respond to them, and we help you all across the spectrum of how to become a better landlord. Until then, take care.